The High Court has dismissed an application by Nana Ekwe-Friye, the NPP's 2024 parliamentary candidate for Ablekuma North, seeking to halt a planned rerun of parliamentary elections in 19 polling stations constituency on July 11, 2025. The motion for interim injunction was dismissed for being unmeritorious by Justice Ali Baba Abutari, who ruled that the balance of convenience favors the EC's constitutional duty to ensure representation for the people. My colleague Hanson Ajimai joins us live from the courts with more. Hanson, many thanks for joining us. Hello, Hanson.
Welcome. Hello?
Yes. Right. Tell us what the main reason,
Yes.
what was the main reason given by the court for dismissing the application?
So the judge in his ruling noted that the Electoral Commission has a duty and a responsibility to conduct elections and to, at the end of the day, collate and declare results for the constituency to get a member of parliament. It was the view of the judge that a further delay of the Electoral Commission carrying out its activities would impact the people of Ablekuma North, who are supposed to have representation in parliament. He was also of the opinion that if you look at the Electoral Commission, which is a finger of the executive in his own words, will be able to compensate Nana Ekwe-Friye just in case Nana Ekwe-Friye wins the substantive case against the Electoral Commission. And so, in his view, he thought it wise to dismiss the interim injunction application, which was filed ex parte, meaning that there was no representation of the Electoral Commission or of the NDC in court today. But the judge felt that it was important to dismiss the application to allow the Electoral Commission to carry out its duty. The NPP candidate's lawyer, Gary Nimako, who also doubles as the director of legal affairs of the opposition party, had argued that the Electoral Commission was under a mandatory duty which was directed by the High Court for the Electoral Commission to complete collation in the constituency. And if the lawyer felt that if the Electoral Commission, in undertaking this order by the High Court, faced any challenges, the reasonable thing to do and the lawful thing to do was to come back to the High Court for the High Court judge of a variation of the order of the High Court. He felt that the Electoral Commission did not have the power and mandate to, on its own, vary an order of the court. And he also indicated that if you look at the Electoral Commission or election regulations, a rerun can only be ordered when there's a tie between the candidates in question. But he argues that in this instance, the Electoral Commission has not met the point, or has not met this particular legal rule that it can order a rerun because there's no proof of any tie between Nana Ekwe-Friye and Irabena Obin. And so he felt that that decision by the Electoral Commission in itself was illegal, and one that he described as unnecessary and also contemptuous of the orders of the court. The High Court judge also wondered about issues relating to the Electoral Commission's communication that has not been able to verify 19 polling stations, and asked the NPP's lawyer if collation in any way can be done for these 19 polling stations without a rerun if the Electoral Commission is not able to verify the results. The NPP's candidate gave indications that there are pink sheets to these results for which the Electoral Commission can rely on. But the judge, in his ruling on the matter, said the lawyer was not able to prove that the laws allow for collation of results if those results cannot be verified or authenticated by the Electoral Commission. So What this means is that the interim injunction has been dismissed. The Electoral Commission at the moment do not have any obstacle impeding it from carrying out the July 11 rerun in the 19 polling stations in Ablekuma North. But it is important to stress that this interim injunction was filed as an offshoot of a judicial review application filed by Nana Ekuye-Afriyie. So the substantive case is that Nana Ekuye-Afriyie is seeking to declare the decision by the Electoral Commission to rerun polls in 19 polling stations as unlawful. And so date is yet to be scheduled for the hearing of this substantive matter. But it is of the opinion of the judge that even if Nana Ekuye-Afriyie wins that substantive matter, she can be compensated by the Electoral Commission, and as a result of that, was not inclined to grant the injunction application.
All right, Hanson, thank you very much for bringing us up to speed on what occurred in court today.